Father, please guide my mind, my heart, and my soul. I pray for our children, our elderly, every man, woman, and child that is suffering, that is in need, that is in famine, that is in, hopefully not in war. Please keep us safe and give us strength, Father, and help us to love one another. Amen. In John 7:51, this is Nicodemus. He said, "Doth our law judge any man before it hear him, and know what he doeth?" John 8:15-18, it says, "This is the words of Christ. Ye judge after the flesh. I judge no man. And yet if I judge, my judgment is true, for I am not alone, but I and the Father that sent me. It is also written in your law that the testimony of two men is true. I am one that bear witness of myself, and the Father that sent me beareth witness of me." Continuing in John 8, what I got written down here, 2-11. "Early in the morning he came again into the temple, and all the people came unto him. He sat down, taught them. The scribes and Pharisees brought unto him a woman taken in adultery. And they had set her in the midst. They say unto him, Master, this woman was taken in adultery in the very act. Now Moses in the law commanded us that such should be stoned. What sayest thou? This they said, tempting him, that they might have to accuse him. And Jesus stooped down, and with his finger wrote on the ground, as though he heard them not. So when they continued asking him, he lifted up himself, and said unto them, He that is without sin among you, let him first cast a stone at her. And again he stooped down and wrote on the ground. And they which heard it, being convicted by their own conscience, went out one by one, beginning at the eldest even to the last. And Jesus was left alone, and the woman standing in the midst. When Jesus had lifted up himself and saw none but the woman, he said unto her, Woman, where are those thine accusers? Hath no man condemned thee? She said, No man, Lord. Jesus said unto her, Neither do I condemn thee. Go, sin no more. Hard topic. Not doing out of spite. You can think what you're welcome to think, and hopefully the First Amendment is going to hold true today, because there's nothing. This is out of the horse's mouth. This is just what it is. Okay, let's go. I believe the first part, I'm going to do about 4 or 5 parts out of this one. This first part is concerning business courts, and then I'll elaborate after that. Okay.
Bringing a case in front of the secular court, but what about applying secular law even if you're going to adjudicate a case in front of the Beis Din? This is a very hot contemporary topic, because people enter into business transactions and the like, sometimes really wanting to rely upon what we call the customs of the marketplace, what the standards are of secular society. You enter into a business transaction, and very often the expectations are that the business transaction will be conducted according to the norms of secular law. If the parties have stipulated that in their contract, is that something that should be honored by the Beis Din, or is it something that the Beis Din should not honor, because maybe that is on some level a violation of lifneihem, in front of them? You should go in front of the Jewish law judges, meaning the Jewish legal system, below lifnei arkos, and not in front of a secular legal system. And is it not on some level submitting to a secular legal system when you instruct the Beis Din to decide a case according to a secular law? This became a hot button issue in recent times, when the Medina Israel, was founded going back, of course, 75 years ago. And there was a system of courts that was put into place at the time that was based upon English law and Ottoman law and other legal systems, but not Jewish law per se, what we refer to nowadays as the Bagatz. And all of the judges, at least at the time, the judges were perfectly Jewish, but nonetheless, the code of law that they were called upon to apply was a code of law that was not premised upon Torah law principles per se. Some of you may recall that there was a movement known as the Mishpat Ivri movement that was headed by certain very fine scholars such as Menachem Elon, which stood for the proposition that the courts in Israel should certainly take into account Jewish law. They should be conversant in Jewish law. And Menachem Elon, who of course sat as a judge in the Israeli court system, made sure that whenever he wrote a decision, he incorporated a section which would analyze the applicable Jewish law that would be relevant to the subject at hand. But despite the fact that the Mishpat Ivri movement certainly referenced Jewish law, the cases were not, strictly speaking, adjudicated based on Jewish law. Menachem Elon was very good at figuring out ways of saying, well, according to Jewish law principles, we're supposed to defer to such concepts as Dina de Malchus Dina, the law of the land is the law, and even the idea of Minas Ochim, that you follow the customs of the marketplace. So therefore he said that based on an admixture of these principles, very often the outcome would be the same, even if strictly speaking, according to Jewish law, the outcome would be different. And there was much discussion about whether this assumption and this approach of Menachem Elon and the Mishpat movement was really a sound approach or not. The Chazon Ish famously wrote that this court system that was set up in Eretz Yisrael was intrinsically defective. I'll just make short reference of this before we speak about the Rashba a little bit more. The Chazon Ish, in his commentary to Masechah Sanhedrin, Siman Tezvav, the Sifkat and Dalet, said that if you would set up a system of laws that was based upon Boros Nishbarim, he said broken wells, and you would leave the Makor Mayim Chayim, you would leave the Torah system of law, which is our foundation and the waters that we drink from, that even if Yaskimov, everybody would agree upon some sort of an alternative legal system, that would be considered to be a violation, a desecration of the Torah. And he said that this is an application of the second part of the principle, which the Gemara speaks about. You should place the laws in front of the judges and not in front of the secular courts. So he said, also, you have to place your disputes in front of the Jewish law judges and not in front of individuals who are unlearned, lay people who do not know how to apply Jewish law properly. Now the Ramban, in his commentary on the Chumash, says that second part of the principle is different in part from the first part. Namely, when it comes to adjudicating a dispute in front of unlearned laymen, so then you could say, well, says that this is not something we're supposed to do lechatchila, but if both parties agree that they're going to take some ignoramus to decide their dispute, that they would be allowed to do so. They can make a tanai. Generally speaking,
that'd be arbitration, right?
Sure, you have a principle called tanai shebamon kayim. It would be arbitration because the person wouldn't strictly speaking be a full-fledged dayan, but the person would just be deciding the cases according to their sound judgment, but not necessarily utilizing a separate standalone legal system. So that would be okay. However, if a person would decide, two people would decide, they're going to adjudicate their case in front of they're going to make a tanai, a condition. For us, it's okay. We say, no, that's not okay. The Shulchan Aruch rules is null and void. That's what the Ramban says. Why is it null and void? It's null and void because it's considered to be making a condition with respect to something which is not just a davar shebamamon, something which is a monetary matter, something which is a davar shebe'isr. It's a ritual prohibition to go in front of the secular courts. It's a desecration of God's name. The Rambam says somebody is considered like your Meir Yad B'Torah's Moshe Rabbeinu. You're raising up your hand against the Torah Moshe Rabbeinu. So here, that's exactly what the Chazon Ish says. He says it doesn't matter if you come in front of non-Jews. Uven Yisrael sheshofet al pi chukim v'duyim. You're going to come in front of going to decide the case according to laws that they have made up. And he says, it's even worse. They have switched and they have reviled the laws of the Torah. for an alternative legal system. Even if everybody would agree, he says it's not considered to be a valid agreement. Says because you're raising your hand against the Torah Moshe, and you create an alternative legal system, even if all the judges would be Jewish, but they're bidden and duty bound to apply secular law. So here, we no longer have the principle of the Ramban that just because they happen to be Jewish, you can accept them, because this is an example where you're actually accepting a different legal system upon yourself, and that is considered to be Meir Yad b'Torahs Moshe Rabbeinu, lifting up your hand against Torahs Moshe Rabbeinu. So the question is...
Okay, it's a lot to take in. The first part of that, he started off with business courts, though, okay? This may seem out of left field. It's not prophetic in any instance. It's just a weird connection. So watch this. We're going to go back to this because this is very interesting. And he says a lot about non-Jews also. So this is just what I saw this a while back, but it's very interesting. Oklahoma is an anti-BDS state. It's not. I don't agree with any of it, really. I agree but if people want to boycott anybody, that'll be able to do that. That it's a violation of people's First Amendment rights. But look at what this says. This is Senate Bill 632. Where's the description of it? Okay, look at what it says right here. Bill title: Business Courts. Creating business court divisions in certain judicial districts. Providing for appointment of business court judges. Specifying authority and jurisdiction of business court. Like I said, I'm not trying to... It may be an odd deal to... But it is interesting. It is very interesting, isn't it? Now this is this year. So it says there's a need for a court in Oklahoma's most populated counties, but there's a very weird precedent going on. Maybe I'll say that, with specific jurisdictions over actions involving such commercial issues. With a population in excess of 500,000. But, okay, so there will be one in Oklahoma County, that's Oklahoma City. And then Business Court Division 2 shall be located in Tulsa County and quartered in Tulsa at the Court of Civil Appeals. So, except as otherwise provided by the Board on Judicial Compensation after April 28, 2021, the following judicial officers shall receive... Okay, that's just over their salaries. Okay. They do it. They make pretty good salary. I mean, I didn't think it was $145,000 for the judge of the district, and the associate district judge gets $134,000. That's pretty good lick. Okay, this is what I was getting at, and they word these laws. They're so broad and such written in such gray areas. It's just, and I'm not trying to make a mountain out of a molehill, but it's just weird. And it doesn't seem to be, it's just a weird time we're in. If a governing board of the court fund receives a request from a municipality that court be held within that municipality, and the board determines that sufficient reasons exist for establishing a court, and that sufficient funds and space for a court are made available by the municipality, the board may establish a court presided over by a special judge in that municipality. Now, what is it talking about in that municipality? Unless and until the Supreme Court or the presiding judge of the judicial administrative, you're going to hear that word a lot, district provides otherwise, and excluding any business courts established pursuant to Section 91.7 of this title, the district court shall hold court in the county seat of every county in the district. In any city where a superior court held sessions, so this it looks like they're wording it where we have 77 counties in this state, and it's weird because there was a guy that last year, later in the year, he was trying to get, well, it wasn't later, I think it might be the end of summer. He was trying to get an investigation into a lot of things involving children, and there was some horrible things being done to children, and they had to go get a petition, and I called the number trying to get my name on a petition just to just try to help. Well, you can't put your name on a petition unless you're in that county, which I haven't really looked over the laws, and I don't know how they were or if that's always the way they've been. But it doesn't seem weird that you want an investigation into a state-run agency that the state presides over, involving everybody's children in the state, and they want to make it a county thing. And he said, oh, if I can get an investigation here, then we can start in all 77 counties. Why can't you just do the whole daggum thing? And that's just like if you want something looked in, say I'm in the Panhandle. Let's just say that. And let's say my county's called Water Bottle County. I want an investigation in Water Bottle County. Well, that if you call, like, say you call, let's say my state is called the Sugar State. Let's say I'm living in Sugar State. I'm in Water Bottle County in Sugar State, and I want to call Sugar State, investigate the state investigations of Sugar State. They'll say, you'll get a message. Hey, you need to contact your local authorities. Oh, ain't you state investigations? No, but you got to look at local authorities. Ain't that just weird? It is. So anyway, in all counties of the state, there is created the office of Secretary Bailiff. Okay, maybe this is talking about bailiffs. Yeah. Okay, this looks like it's just laying out the structure for it. Yeah, that's salaries, and it looks like it's kind of in its infancy, but in every county of the state, each district judge and each associate district judge, including business court judges, in counties with a business court division, may by order appoint additional necessary court personnel subject to the approval of the Chief Justice. Okay, how many pages is this? I think it's just like 15 or 20 pages. A district judge who sits regularly in more than one county may employ only one. Okay. This looks like it's just laying out the structure, but still, it's just very weird, isn't it? This cleat, I believe, I don't think it's new. I believe all jailers, and I believe even security guards got to do it, so I'm not knocking it. But it is weird how kind of it kind of has leanings of a secret police, if you will. And they do have a paper on there that says citizens arrest. That should go both ways. So if you got an instance where you're kind of wondering some things, go ask somebody if they're cleat certified, because it's by law they have to tell you that. It's illegal for them to not disclose that. All right, I'm not going to dwell on this, but y'all kind of get my drift. Let's continue. All right, this section is obeying the laws of the land. I don't think this is very long, but then I'll jump to the other portions.
And then we dafka replace it with something else. It sounds like the Lashon of the Rambam. It's a rebellion of sorts against God. Though I know that we've mentioned the principle of Dina D'Malchusei Dina, which is a general idea that we're supposed to follow the laws of the land, and that's of course very relevant to this topic. I think we'll speak to this as we explore the Rashba. about how Dina de Machusi Dina has been unfortunately coupled together with things like V'ahavta L'Recha Kamocha and Kavod Habrios, which are all legitimate concepts in halacha, but they are expanded beyond their limits many times. Dina de Machusi Dina, as Rav Reese as you mentioned, it applies to dine manus, to monetary matters, but you can't apply dina de dina certainly to ritual matters, to marital matters. But even within monetary matters, we'll see in the Rashba, I think, in the moment, that it's not so pashut, it's not so simple that we could just use dina de dina as this elastic concept to be.
I wonder whenever we're talking about in marital matters, if they're trying to say that you can't use no fault divorce anymore. I wonder if that kind of falls into some of this. It's just something to think about.
To basically use perforated pages on our chelek of Choshe Mishpat.
That's 100% correct. And that's a perfect segue into the tshuva of the Rashba. So the question becomes, what if it's not a replacement of the entire Torah legal system, but parties in an individual case just happen to come in front of the Beis Din and they stipulated in their contract that they want their business dealing to be conducted according to secular law? Is that legitimate or not? Is that also included in what the Chazon Ish was fulminating about? Or is this something which is more legitimate? We do know that, as we mentioned earlier, parties are allowed to make conditions. The Mishnah in Bava Metzia Daf Tzadi Dalet says that a Shoel Chinam can stipulate he'll have the obligations of a Shomer Chinam can stipulate the Shomer Sacher. The Shomer Sacher can stipulate he'll have the obligations of a Shomer Chinam, and that's considered to be perfectly fine. And we consider that to be binding based on the principle of Kol Tanai Shebamam Kayim. So what if instead of saying, oh, as a Shomer Chinam, I'll take upon myself to be obligated to Geneva Babedu like a Shomer Sacher, the Shomer Chinam says, I'll take upon myself to be obligated according to whatever secular law would obligate me to be liable for. So is that considered to be beyond the pale? So the Rashba dealt with a case, this is Chelik Bava Siman Reishon and Dalet, where there was a situation where
all right, then he kind of goes into something else, but we'll jump ahead. That was kind of off base. I apologize for that, y'all. But 18, it's about 18. So let's go by right here. All right.
Okay, that even taking upon yourself a secular law, if it is a base of
and here in a minute, just to give you a perspective, this section is about obeying the legal system of non-Jews. Here we go.
Desire to follow the ways of the non-Jews because you respect their legal system more than our own legal system. So then he says that would be a terrible, terrible thing. And he goes on to say, the kol sheken, and how much more so, you're going to do away with the whole notion of inheritance of a father, and you're going to be mapil chomos haTorah. You're going to raise down, you're going to tear down the walls of the Torah, and you're going to destroy all of the roots and all of the branches of the Torah. That would not be a good thing. And that's the end of the second part of the tshuva by the Rashba. In other words, the Rashba says you do it as a matter of business custom or common personal family custom within the Jewish community, no problem. You're doing it because of the fact that you want to imitate the secular laws and you want to uproot our system and replace it with their system. So that's when you have a problem. Yes.
If I may even supplement, there was.
So that's. Anyway, we're going to go to 20. 20 is talking about the law and land, law of land.
Rashba said that line in connection with the next part of the tshuva, part 3 of the tshuva. Part 3 of the tshuva begins with the words, "Ve'omer ani shekol hasomet b'zeh lo ma shemuta mishum dina d'malchus dina Torah, Begazlanu. Anybody who thinks that you should follow the secular law because of the principle of Dina Damachusa, you follow the law of the land, that's a big mistake. And if you're going to take money from somebody on that basis, you're going to be considered to be a Gazlan. Why is that? As the Rashba points out, the principle of the law of the land being the law is only applicable to a very small subset of governmental powers, such as
ability to levy tax. So in 22, he continues on that same premises about kind of like, he talks about Torah would become irrelevant. So the question, and after all of that, of the Rosh, I believe, sorry if I didn't pronounce that, but it says Rashba right here, but I think he's speaking in his, in Judaism. Finally backtracks and the Rashba says, but where to what agree is relevant. Yes, when it comes to taxes, when it comes to building bridges and stuff in eminent domain and things of that variety. It says so too if you have a transaction between two Jews in which the two Jews accept upon themselves that they're going to follow with respect to an individualized transaction. When it comes to monetary matter, you can obligate yourself to give somebody something that not obligated to give. Just like, can he say he's going to take apart himself the obligations of a Shaul, of a borrower? That'll be, for example, so what in the world is he backtracking? Yeah, you cannot, that absurd in his position that you cannot to take upon yourself these laws to secular courts. And he says it's all fine and dandy. I don't think the transcript is following him very well. Let's go to 32, and it says replacing Torah with secular. I know, I'm sorry, I bombed this one, but I'm trying, y'all.
We look into these things and figure out the appropriate enactments, and that's why you need the guidance of a Rashba Chazon Ish to figure out even how to regulate the principle of Lifnei Lo Lifnei Hakos. The bottom line is, you can't go to secular courts for anything. In front of a Bezdin, there are occasions when it would be appropriate to apply secular law when it's in accordance with principles of Tanai Shmemamon or Minhag HaSochrim, or the limited arena of the broad-based economic regulations that fall under the rubric of Dina de Malchus Adina, but to uproot the entire system of Torah law in order to replace it with secular law, that is beyond the bounds, that would be something that would be prohibited.
So very briefly, halacha l'maisa, in Eretz Yisrael, going to a court in Israel. What's the issue there? If one goes to a court, which is presumably Jews are presiding over it, but they're using mishpat ivri or something that's not purely halachic, and then also, what about in America? When someone goes to, let's say, the Basin of America and they do arbitration, are these decisions always being made based on the Torah? And if not, then is that okay? I know that's a lot for like 2 minutes, but
it's a lot for 2 minutes. But
so they are talking about using Jewish courts in America, and I think in New York they vote in what they call Jewish blocks. So I don't know if they have Torah courts or the halakhic, whatever you say, the halakhic. I don't know if they have them in New York. I don't know if they have them in America. But you see what they're referring to. So continue.
But in Eretz Yisrael, the people should go to the Batei Din. There are Batei Din. The Batei Din have been established by the Rabbanut that have authority when it comes to marriage and divorce and personal matters. That they are not given authority for some reason to adjudicate monetary disputes, but people can, through arbitration, go to the other Batei Din that are around. There's some very fine Batei Din, Eretz Chemda, Nesivos HaMishpah. There are very fine Batei Din for that parties can go to, and that really is halakhically based on what the Chazon Ish wrote, exactly what people should do. Here in America, Baruch Hashem, we have Batei Din here as well. You go to the Bezdin of America, so there's a principle. The Bezdin of America has in its rule book rules and procedures that if parties do decide to choose that they want their dispute to be adjudicated according to secular law, so then the Bezdin will apply that choice to the fullest extent allowed under Jewish law. If it's something that's beyond the pale of Jewish law, because of the fact that, for example, it's a ribbis transaction, and ribbis is not a monetary matter, it's a ritual prohibition, so then the condition doesn't count. However, if the condition was in accordance with Minhag HaSochrim, they just wanted to follow the standards of It wasn't because they were looking to uproot the Torah. So then, even according to the tshuva of the Rashba, the way that we paskin in Shulchan Aruch, that would be perfectly fine. To say that every single monetary law of the secular system is automatically applicable because of Dina de Malchusa, that's not something that the Bez in America would say, and that's something what we do. Certainly, paskin la halacha, as the Rashba said, that we're not going to uproot all the sperm of Rabbeinu, everybody who came afterwards, but Torah law still remains extremely relevant and extremely primary and paramount in all of our lives, as it should be.
Okay, he clarified that then. So he said it's not to uproot it. But there's just a lot of being thrown around about noahidism and wanting to set up that in America, and they call it the West. So I'm just wanting to kind of see out of the horse's mouth per se. This is Rabbi Misrachi. Let's hear what he has to say about witnesses and the death penalty involving Goyim.
How many witnesses you need to convict a Gentile and find him guilty for execution? One. You don't need two. One witness.
In my Father's word in John 8, it says, you yourselves use the law to by two witnesses. We'll go back to it here in a minute.
How many judges? How many judges? How many judges you need to convict a Jew? 71. Sanhedrin. 71. And if there is 36 against 35, you can't kill him. You need more than one difference. And if all 71 found him guilty, you let him go free. It's a biased court. Something is not right here. Not one judge found anything to his favor. Cannot be. It's conspiracy. By the Goyim, how many judges you need? No? Just like today in a court, one. What happened by the Goyim? If a woman is a witness, by the Jews, a woman cannot be a witness. By the Goyim, if a woman testify and based on that you have to execute him. Do you execute a Goy based on the testimony of a woman? No. Even a non-Jewish woman cannot be a witness for Goyim. Goyim cannot be witness in a Jewish court in a matter that relates to Jews. Unless if it's called Masiach Lefi Tumo. Masiach Lefi Tumo means the Goy spoke to another Goy and somebody heard it. The judge heard it. And he heard the conversation. Since now they speak between them, they don't come and have a conspiracy in court trying to convince the innocent person. They talk between them. So whatever you heard then you can use as a testimony. But if you need the Goy to come and testify in a Jewish court and based on that you have to kill the Jew, you're not allowed. Also,
he said, if a Jew's in court and all 71 of the Sanhedrin find him guilty, you got to let him go free. It's conspiracy. He didn't say that he said Goyim means one nation or nations. For any person that is a non-Jew, only one judge. This is Rafi Mallet.
To be teachers of Tanakh or teachers of Torah, they say things that are totally unfounded, and among them, that's what gets bandied about so much, it drives me crazy, is that there's no difference in the law between a Jew and a non-Jew. They love to quote right out of context that the stranger and the Israelite shall have one Torah, one law for the stranger and the Israelite. There's one law for everybody, except if you read the verses that come right before it, when it talks about the laws of a Paschal lamb. The son of the foreigner may not eat of it. The uncircumcised may not eat of it. It says a toshav, which means a resident, may not eat of it. A sachir, which means a hired worker, may not eat of it. And the stranger shall have one law with the Israelite and eat it. If everybody has the same law, why is the Torah specifically in the same section where it says the stranger and the Israelite shall have one law? It says, but all these other guys, no. A stranger is what we call today a convert, and
he speaks about the Noahide commandments for courts of law. We'll just hear just a minute or two of this one.
Presented in all the books speaking about the 7 Noahide laws. The Rambam writes that the mitzvah of dinim is that every Gentile society, every B'nai Noach government and city should erect a court that should judge the people according to the laws of Sheva Mitzvot B'nai Noach, and including punishing those that demand punishment, as explained elsewhere in the book, and other details that the Rambam does mention. For example, education of the society and bringing up the ideas and teaching and having a correct influence on the society, that they should know the laws in a correct manner. The Rambam then adds another point, which is controversial.
Not even the laws themselves, but the interpretations of the laws.
And problematic. The Rambam says, and if a court or a judge or a witness, that means a capable witness, that saw a case that demands judgment, and he refrained from bringing this to the court, or the judge refrained of judging the case, or even refrained from punishing according to the correct law of B'nai Noach, this is considered a transgression. Rambam on the Torah in Parshas Vayish.
And now we're going to define the Rambam. And I'd also like to add, they say that there's only 7 noahide laws, and they is. There's over 600 sub-laws. So don't get that twisted, because when you see all 7 in context and right there in front of you, they don't look that bad. But there's 600 and something sub-laws. Rambam is also Maimonides. He was from 1138 to 1204, commonly known as Maimonides, and also referred by the Hebrew acronym Rambam. Was a Sephardic rabbi and philosopher who became one of the most prolific and influential Torah scholars of the Middle Ages. In his time, he was also a preeminent astronomer and physician, serving as the personal physician of Saladin. My Father's word says, "Open thy mouth, judge righteously. Plead the cause of the poor and needy." And I charged your judges at that time, saying, "Hear the causes between your brethren, and judge righteously between every man and his brother, and the stranger that is with him." In Proverbs 80 says, "By me princes rule and nobles, even all the judges of the earth. Judge not according to the appearance, but judge righteous judgment." Let's continue. America's Fourth Amendment. We have a great piece of paper, and it's not outdated. It's just being used wrongly, and by people that just, I don't know, maybe they want to enrich themselves, maybe they don't care, maybe there really is some kind of secret legislation and being carried about. We have a great piece of paper that's called the Constitution, and it's not just a piece of paper. It's given to us by some very, very good men. The Fourth Amendment protects all individuals, all of us. It protects from unreasonable searches and seizures, requiring warrants based on probable cause and specifying the place to be searched and items to be seized. Let's go to the next one. It's called the Fifth Amendment. It protects individuals, all individuals, from self-incrimination. Ensures due process and prohibits double jeopardy, and requires just compensation when private property is taken for public use. The double jeopardy clause prevents someone from being tried twice for the same crime by the same government, federal or state. Protects individuals from being compelled to testify against themselves in a criminal case, often invoked as pleading the fifth. Guarantees that the government must follow fair legal procedures when depriving someone of life, liberty, or property. Requires the government to provide just compensation when it takes private property for public use. eminent domain. Let's talk about the Sixth Amendment. Guarantees the right to a speedy and public trial, an impartial jury. Is a Skype trial a public trial? We have to protect the victims. And the assistance of counsel in criminal prosecutions. The public trial aspect ensures transparency and accountability in the legal process. Ensures that the jury is free from bias and fairly represents a cross-section of the community. The jury must come from the state and district where the crime is committed, and the district must have been previously established by law. The accused must be informed of the charges against them so they can adequately prepare their defense. Isn't that wonderful law? Imagine if that was just this is what we're going to stand on. Given by God, we're honorable people. This protects me. I'm the judge that protects the jury if they were in that situation, and it protects the accused. Have you ever heard of if people are guilty, God will find them out. It guarantees the right of the accused to confront and cross-examine the witnesses against them. Wait, I must have done that one twice. I did. Sorry, y'all. This is one that I see being. I don't know the context of it, but this is one that I think I found this on a government website a couple of weeks ago. Tribal courts. There's like 500 something tribal courts. But there's a lot of we have a right to sovereignty, but you also have the government as your trustee too, right? So, I mean, how much sovereignty do you really got with Uncle Sam wanting to tell you what to do? Tribal courts have civil jurisdiction over both tribal members and non-tribal members who reside or do business on the reservation. Like we had an act brought in 2020. I wonder if that was retroactive because they've been really wanting to go after make it retroactive. You know what I mean? And like I said, I respect their sovereignty and their ways to do, but they're not being very transparent and open about how things are being applied and what they really are. The definitions are murky at best. And this jurisdiction extends to various civil matters, including family law, contracts, and property disputes. So you take that for what it's worth. But like I said, it's murky. All this stuff is being murky. John 8:32 says, "And ye shall know the truth, and the truth shall make you free. If the Son therefore shall make you free, ye shall be free indeed." Oh, let me show y'all something. It's on this here website. It came to me just now. Let's look this up. All right. You put in these words, and it'll search all Oklahoma bills with these words. Watch this word. Certain people. I love this word. It's being used a lot in law these days. Watch this. Look at all these bills that have certain people in them. I guess I'd have to look up the bill in it. Look, 99%, all these bills have certain people in them. I wonder how it works. I'd probably have to search the bill, I guess. I wonder if you can even search it probably highlights it, huh? Yeah, I'd probably have to. I don't see it. Oh, so it says it on page 11. Well, maybe wrong. I'm wanting to show y'all one of them where it does it just to show you I'm not lying, because it doesn't even define who certain people are. But it'll say like these contracts shall be null and void unless the courts decide certain people, or something like that. It's loony. I mean, it's just loony how this stuff is being defined. And also, I wanted to, just clarify, I'm not like, just trying to throw it out there just to be throwing it out there. I'm just saying, we need to, be aware of these things. We can't, we're just men trying to look out for all people and for what's happening to our nations and what's happening to our children and our elderly and our women and our people that, even our politicians and our leaders. All this stuff, it affects us all. God is not the author of confusion, but of peace, as in all churches of the saints. Jesus, let's see what he said to the Pharisees. He said, "Woe unto you, scribes and Pharisees, hypocrites! For ye compass sea and land to make one proselyte, and when he is made, ye make him twofold more the child of hell than yourselves." This is something I wanted to go over. This is Canary Mission. This is when it's a non-profit that puts a lot of people on the internet, and they say it themselves that they dox people and call their jobs and stuff. But this is the May 16th. This is the definition of anti-Semitism. This is all the stuff that they're trying to. We're not going. This is long, but y'all, if y'all want to look at this, it's on their website. So I just want to make you aware of that. Oh, okay, I got the same thing. All right, let's go to the First Amendment, probably our most important. It guarantees fundamental freedoms, including freedom of religion. That's all religion. It doesn't say Christian. It says all religion. Speech, what I'm doing right now. The press, assembly. That means assembling in church, assembling in peaceful protest, whatever you want. As long as you're not nude and disrupting the peace, do what you want. Assemble. A lot of good things have come out of people getting together and addressing their grievances with the government, and the right to petition the government. That protects us all. How important is that for all of us? Owe no man anything but to love one another, for he that loveth another hath fulfilled the law. And y'all go and look at this. They're like 50 minutes each. There's 4 episodes. There's the one in Britain too, and it's called The Lobby, and this is the USA version. Like I said, they have one in Britain, and they're still on here. That's good. Oh, there's all 4 of them together. They're great. They're really good. And there's no bias in it. They're really good. But y'all have a good Wednesday. It's Thursday. It's the 13th. Yeah, 13th. Y'all have a good day. I'm praying for all y'all, and I hope y'all are well. Hope y'all are eating good. I hope you have shelter. But let's pray for those overseas that are being torn apart and bombed and famished, and it's nuts. The world is nuts. But we have a Savior, and he'll judge. He'll judge, and he'll make it all right. Y'all be good.